Kelly, did we get confirmation from Casey Moran since I don't see the person on the screen? Good evening, everyone. I'd like to welcome everyone and call to order this virtual quality of life and public safety meeting of July 16th, 2026. On my screen, and I am just going to read the names off as I see them. We have our Inspector General Joseph Lopez from Corporation Counsel, Attorney Natalie Fioli Guerreri, Kelly Kirkley Bay from the Office of the Council President and Councilwoman Rosado, Councilman Josh Mixtum, Councilman Alex Thomas, Corporation Counsel Jonathan Harding, from the Hartford Police Department, the Union President, James Rosowski, Hartford Public Access TV, our Town Clerk, Eric Lusa, and we also have the Chair of the CPRB, Andrea Hartman. That is everyone that I am seeing on the screen this evening. This will be a short but quite extensive meeting tonight because we are discussing the Civilian Police Review Board ordinance. And we also have a resolution 2.2, Mayor of Olympulum, with accompanying resolution confirming the appointment of Casey Moran to the Greater Hartford Transit District Board of Directors. Is Casey Moran on the screen? And perhaps I don't see you. I don't believe the person is with us. This committee this committee meeting is being live broadcasted on the following outlets: Comcast 96, Frontier Channel 6032, Hartford Public Access TV.org, HPA-TV Facebook page, HPA-TV's YouTube channel, Roku TV, Apple TV, Amazon TV, and other social media platforms. This meeting will also be rebroadcast on HPA-TV's YouTube channel and Facebook page. Oh, I see that Casey Moran has joined us. I'm going to change a little bit the agenda around, since the CPRB item will be quite extensive as we go through the ordinance. So Casey, item 2.2, Mayor Relumpinum with a company resolution confirming the appointment of Casey Moran to the Greater Hartford Transit District Board of Directors. And the resolution reads as follows: where the Greater Hartford Transit District was established via Connecticut General Statutes, Section 7-273B, to acquire, operate, finance, plan, develop, maintain, and provide alternate forms of land transportation and related services, among other things. And whereas the district is comprised of 16 members, towns represented by appointees who form the board of directors, and whereas the mayor has appointed Casey Moran as a member of said board, now therefore be it resolved that the Court of Common Council hereby confirms the following appointment to the Greater Hartford Transit District Board of Directors, filling a vacancy for a term expiring July of 2030. Casey Moran, 1 Linden Place, Hartford, Connecticut, 06106, for the record. And Mr. Moran, you have the floor for a brief introduction. And why did you decide to put forth your resume for this board?
Thank you. Excited to be here and excited for the opportunity. I live here in Hartford, as mentioned, and as somebody who gets around primarily on 2 feet via transit and 2 wheels, the city is wonderful, great, and there's definitely a great opportunity to better connect the city and ensure that our Greater Hartford Transit District is the best version of itself. And when I heard that there were some vacancies, I was excited to put my name forward to help fill the role that we think that it can be here in Hartford.
Thank you. And as you know, this is a volunteer position, so we appreciate your service to the city. With that being said, I'm going to open it up to my council colleagues, Councilman Thomas, Councilman Mixtum. Do you have any questions for Mr. Moran?
I do, Madam Chair.
You have the floor.
Thank you. Casey, just, I agree with Councilwoman Rosado. I'm really glad that you're doing this. I'm just curious, like, what's the most pressing issue that you'd like to address, get into on the Greater Hartford Transit District Board?
It's a great question, and I have done a little bit of legwork on my own, speaking with folks who sit on the Norwalk Transit District and the New Haven Transit District to understand what their local realities are there. And I understand that there's transit district serves 2 roles in Hartford, 2.5 roles maybe. It owns Union Station, it runs the ADA accessible shuttle service, and it has some other powers that are granted to it. And getting around Hartford the way I do has really made me, or it's really become clear to me what works well and what doesn't. So I'm excited to explore the opportunities through the Greater Hartford Transit District to see if there's ways that we can push for more and better here in the city of Hartford. I don't want to get into specifics exactly because I know that there are certain fence lines between Greater Hartford Transit District and Condot, and I don't want to come in pretending that I know everything because I've never been in this role before, and I want to better understand exactly where those fence lines are. But from my time speaking with those who do work in those other districts or who are on the boards of those other districts, I think there is a great opportunity here by better empowering the control that we could have through the Greater Hartford Transit District to push for better and more out of the overall citywide transit system.
Thank you.
Councilman Thomas, do you have any questions or comments?
Hey, thank you, Madam Chair. I don't have any questions. I just wanted to thank you, brother, for your service onto the city. And it seems like you're going to be a great addition to the board. So thank you so much for your service. Appreciate it.
Thank you.
Thank you, Councilman. So without further ado, the chair will entertain a motion.
Yes, I would like to make a motion to send back his recommendation back to the full council with a favorable recommendation from the Safety Commission.
Do I have a second?
Safety Committee.
Second.
So the motion has been made and properly second. All those in favor?
Aye.
Aye.
Aye. Any opposed? Any abstentions? The ayes have it. This resolution will be sent back to council with a favorable recommendation. Thank you so much, Mr. Moran. And you can wish to stay or log off. Now we move on to item 2.1 of the agenda, which is Councilwoman Mally Rosado, Councilman John Gale, Council President Thomas Clark, Councilman Josh Mixtum, Councilman Alex Thomas, Councilwoman Mallory Rossetti, Councilwoman Shirley Surgeon, with the accompanying ordinance amending Article 5, Division 5, Section 2-196 of the Municipal Code of Hartford to make revisions to the Civilian Police Review Board. Now, because this is such an extensive and very important ordinance, we're going to discuss it here today, but will not be referring it back to council. There is a public hearing scheduled for Monday, July 20th, 2026. So without further ado, we do have here our Inspector General, Joseph Lopez, and we also have from the CPRB board, Andrea Hartman. The floor is yours, Inspector General.
Okay, thank you so much. Thank you, council members. Can you hear me?
Oh,
Yes? Okay. And may I share a screen? I wanted to go through a presentation.
Yes.
I appreciate this time very much. All right. All right, if I can just ask, is that PowerPoint properly up, the proper view? Is that up? Okay.
Yeah,
it
we
is.
see it.
Yes, you can see it?
Yeah, I could just see the agenda as the first page.
Yes, just as a screen.
Yes. Yes.
So thank you very much for having me here, council members. I really appreciate this. You can't even understand how excited I am to finally kind of be here and seeing today happen. Very excited about the proposed amendments. And I want to let you know that this has been an ongoing problem since 2020, since the amendments were made to the last amendments were made. I've been at the post here since November of 2024. I can represent for the last 18 or 19 months that I've had incredible difficulties performing my job as Inspector General, and I know the board has had tremendous difficulties performing their mandate. It's come to a point where I am seeking help. The board is seeking help. I've exhausted all my options. I've met with the chief, the union. I've met with internal affairs. Luckily, I also have the support of council and of corp counsel, John Harding. I know he's on here tonight. So things have been moving along, but we're at an impasse here. And I will say this is the most comprehensive. Everybody knows that it's the most comprehensive accountability ordinance framework in Connecticut. But that's on paper. And honestly, and in full candor, and this is not mere hyperbole, but the CPRB envisioned by council back in 2020 with those amendments, that's not what you have today. We've got issues that have been going on for years and years and years of roadblocks that prevent the CPRB from carrying out its mandate. by city law and to the people of the city of Hartford. People make fun of me on the board, but I call it the People's Ordinance. That's what this is, okay? The People's Ordinance. And we're at a crossroads, and I suggest and I propose, I submit that there are either amendments to fix the CPRB now, enough is enough, or we just accept the fact that it's going to fall short of the vision. It's just not going to make it. So we are at a crossroads, and I appreciate this. What are the problems? The bottom line is what I'm going to call discovery, meaning access to evidence, documents, and materials, the items needed for us to conduct our investigation. Another longstanding problem, the chief of police not committing to wait for the CPRB's findings before proceeding with his findings. Arbitration, right? The teeth, the enforcement component of this ordinance. Union and challenges to the arbitration process. It's now a pending challenge before the labor board, and you know, this is going to keep rearing its head until I believe the amendment clarifies some language. Subpoenas, a very powerful tool for getting to interview witnesses and getting documents. Hartford Police Department's and the union's challenges to my and the board issuing subpoenas recently after 18 months of trying everything else, and our inability to interview officers, and that has been because the union has blocked that. And the last thing is just a suggestion that if you're looking at the ordinance, perhaps address independence for the Inspector General position. I'm not suggesting that there's any political issue here today as I work here. I'm suggesting that moving forward and going forward as we look down the road, the ordinance really should be set up so that whoever's sitting in this spot, it cannot be influenced by political pressures, and it's an independent watchdog, which is the purpose of an Inspector General. And we've seen what can happen, like what we see in the federal government, when somebody can just start firing Inspector Generals and get rid of that independence. So what I would ask with respect to the ordinance, and then I'll move on to the language, we really need to clarify that FOI, public records, freedom of information, that is not the appropriate standard to assess what the police department turns over to the Inspector General. And we need to require and make sure that Internal Affairs of the Hartford Police Department is turning over a complete copy of the evidence and in a timely manner. That has been a problem for years. We need to reinforce that the chief of police must wait for the CPRB findings before issuing their final decision. We need to address the arbitration language to make clear that arbitration is adjudicatory. It's a decision on whether or not an officer committed misconduct. It has nothing to do with discipline. We need to address that language because right now the union is making a claim that it is discipline and therefore conflicts with their collective bargaining agreement. So the language should be fixed to address that challenge. And then subpoenas. Again, the Hartford Police Department and the union are challenging the subpoenas, questioning whether the ordinance correctly wrote up the subpoena powers, questioning the authority of the Inspector General to issue subpoenas, questioning the authority to participate in officer interviews. And we also, by addressing that, I also suggest we have to add language to clarify that when officers are interviewed, they have certain constitutional protections, the same ones that they have when they're interviewed by Internal Affairs. So that's the proposed solution. That is what I would call the ask. The documents that were submitted, the proposed amendments, there's 10 pages. Obviously, council knows it's in red, but for those that may be tuning in, Councilwoman Rosado, you can speed me up if you want. I'm just going to go through all of these, but if you need me to pick up the pace, that's perfectly fine, or if there's questions. But if I can start just on the very, very first page, and what I did is on the left-hand side, you'll see the page number that this language lines up to, the page number and the proposed ordinances. So the first language is a proposal to add language that would establish some autonomy and independence for the Inspector General, that would establish a chain of command to make clear that the Inspector General reports to the Civilian Police Review Board, that right now the Office of Equity and Opportunity is supervising the Inspector General's position. The person that runs that happens to be a wonderful person that I like very much. But as we look forward, the Inspector General should be supervised by CPRB, not by someone in the executive branch directly. It has to be by the CPRB. That's why that language is there. And that language just specifies that IG is an independent watchdog. It needs to be independent for impartiality, for legitimacy, and it is a requirement that the Inspector General report directly to the chair, but obviously language in there that the Inspector General is an employee of the City of Hartford and must comply, obviously, with all policy rules and administrative procedures. And that's what that language is in red there. With respect to page 2, this I think is one of the most important issues that I would hope that the amendments would address. Currently, basically under the composition section, this is the language that talks about what the Inspector General has a right to receive from the police department. And I highlighted in blue, which is the language that's in there now, which has created major headaches for me and the board for years. Somebody somehow, somewhere told IA, I'm speculating, that the interpretation of as allowed by existing statutes or requirements of law, that means FOI. And that's been deeply ingrained for years and years. I've written letters, I've met, I've talked to everybody. Other than Corp Counsel, who has helped me tremendously with this, I can't get anybody to budge on this. I know the council did not mean FOI to govern what papers CPRB got. So my proposal is just to, if you see the red language, get rid of that language as required by law, and add section F4, which specifies with some specificity what is supposed to be turned over. That is a major problem, that language in blue. This language on page 3 is simply for improvement. This is just something that I thought would help. If there's a designee that's available from the chief's office to sit there and answer questions, if the board has one, about policies or procedures, that might help the board tremendously. If the Inspector General doesn't know a certain area, or if the board is asking, well, let me ask the member of the department who's here, what is your interpretation of a certain policy or procedure? The board should have that available. I think it would be helpful that the board can ask a question to someone from the department with knowledge. The language on page 4 is simply just changing some language around. It doesn't change anything. I just think it reads better. And it's really what was there before, but that the board on its own can direct the Inspector General to investigate even without a formal complaint when it's in the public interest. So there's no substantive change there, just a change of language. With respect to page 5, again, I go back to autonomy. My request is to change the language to make clear that that the Inspector General is an autonomous position, that yes, it would be great if the Office of Equity and Opportunity can assist and provide administrative assistance, and that would be greatly appreciated, and they do, but it should not be supervision. Okay. With respect to page 6, the language there, again, that has to do with evidence. One of the problems is that we do not get evidence in a timely manner. I'm supposed to do my investigations within 45 days. I cannot do those in 45 days if I don't get evidence turned over. This provision basically tolls the clock, basically says, okay, it's 45 days after the Inspector General gets substantial materials, meaning I may not have everything but as long as I have enough of the documents to proceed with my investigation, this language protects, is a guardrail on the 45-day requirement. It stops the clock and it puts the onus on the police department. Turn it over, and then their clock starts. I think this is very important. I'm happy at some point to entertain questions if you have. But with respect to the Inspector General interviewing officers, the last Inspector General had issued or had come up with a memorandum of understanding where he was permitted, and the union had agreed to this, to go and be present at internal affairs interviews and be able to ask his own questions there. That was in an effort to not have officers twice come to answer questions and have them answer questions at the internal affairs office where everybody kind of knew the rules and the process. The union has rescinded on that MOU and has made clear to me that they will not permit their officers to be interviewed by me. So we have no other choice but to do it through subpoena. But I would highly recommend that this language be added. The language that makes clear that the Inspector General should, right? The goal is to try to coordinate with internal affairs, to try to have the Inspector General on cases he wants to interview officers, try to coordinate with them and do it at the police department. However, if that can't happen, and the Inspector General, through the authority of the CPRB, issues a subpoena, that police officers must answer questions, but they have the same constitutional protections as they would when they're in front of internal affairs, and there they must answer questions. There's U.S. Supreme Court decisions. There's two of them, Garrity and Weingarten, that are often thrown out there. But the same procedures that safeguard these officers when they're forced to answer questions at internal affairs are the same ones that should apply here. So that language should just make it clear. With respect to number 6, this is really just language to make clear that the chief must wait. It provides also, it's a balance, okay? It is a balance of interests. The board has an interest in having the chief wait for its findings, but clearly the board shouldn't be able to take forever to turn over a document. So this is a nice compromise. It says the chief must wait. However, if 60 days elapses and the CPRB has not yet submitted its findings, or for good cause, that the mayor finds good cause, the chief, after notifying the board, may proceed without waiting for the board's determination. So it's a balance. The chief must wait, but there are some time limits on CPRB. On the other hand, even if the chief goes forward, the CPRB always has the right to ask the chief to relook at its investigation and reopen. However, the language at the bottom is very important. If the chief reopens the investigation, that chief cannot issue or alter any discipline that's already happened. So we want to make very clear that we don't step on the collective bargaining agreement with respect to discipline. And I think that last sentence gets us there. I think that's very important language to make sure the chief has to wait, but the CPRB has a mandate to get this stuff done in a timely manner. With respect to page 7, I just wanted to make sure that there is an obligation placed on the chief to notify CPRB of the chief's findings and determinations. Currently, I have to send emails and letters constantly, and they are not always responsive to these requests as to what happened with this case. Did the chief make a finding or not? I need to report back to the board. The language puts the onus on the chief to notify the CPRB. Notify me, and I'll notify the CPRB. The language at the bottom also talks about arbitration and makes clear that the arbitration process can't fail because we don't have anybody on the list. Currently, in 2026, we finally had our very first arbitration hearing. We have one person on the eligible arbitration list. So this language would make sure that there has to be kind of a standing committee, which we'll get to make sure that there's always someone on that list. But that in no event, this is a guardrail, in no event is arbitration going to fail because there happens to be nobody on that list. In that event, the parties have to meet with corporation counsel and make good efforts to mutually select a qualified arbitrator. I think that language is important. The language on page 7 basically just establishes some of the, fleshes out a little bit about what a hearing looks like. I've worked with Corp Counsel John Harding on some of the procedures at our first arbitration hearing, and he wrote a memo. There was a decision made, all the parties participated. This really just kind of incorporates that or codifies that, really that at a minimum, the parties have a right to a hearing on all the evidence, make arguments, present their positions, and submit briefs. It also makes clear that the arbitrator who makes a decision that those reports will not contain the name of anybody that is protected by statute. A domestic violence victim or sexual assault victim or things of that nature. It makes clear those names are not to be published. On page 7, I think we need to add this. I think you need language that there has to be a selection committee that convenes annually or more frequently as needed. You have to maintain a list, and there has to be, in my opinion, at least 5. The chief and the chair have the right to choose, by agreement, to choose off of the list. It seems to me that there should be at least 5 qualified people on there for the chief and the chair to select. And without a standing committee, we have what we have now, which is I have one person that's eligible to hear arbitrations, and if that person tells me tomorrow that they're not eligible to hear the next arbitration, and by the way, we have 1, 2, 3, 4 more lined up, then I have nobody. So without this, there's no arbitration process. If there's no arbitration process, there's no enforcement. There's no accountability. With respect to page 8, again, this goes back to trying to get discovery in a timely manner, meaning evidence, documents, material, the things that the Internal Affairs Division has in its possession, which it uses to investigate these cases. This talks about the Civilian Police Review Board. The ordinance says they're supposed to complete their review within 90 days. That doesn't happen in most cases because most of these cases are old and I can't get them to the board in a timely manner. So this really tolls the clock and says within 90 days, provided that I have substantial materials to complete my report. And that just basically refers back to section D7, which we talked about a minute ago, that you have enough to do the investigation, but the Inspector General, the 45 days doesn't start clicking until he or she has that information. It puts the onus on the police department to get us the materials. And it stops that 45-day clock from running. And suddenly we're out of compliance through no fault of our own. That addresses that. One thing I would suggest, and I hope I'm not stepping out of my lane, but with respect to 8, the language in red is something that I would strongly urge to fix a problem currently, a challenge that the union has made. But I would also point to the highlighted area in blue above, and I'll get to that. But the language here, the union has brought a challenge claiming that arbitration conflicts with their collective bargaining agreement because they claim arbitration usurps or encroaches on the chief of police's ultimate determination of discipline, which discipline is a subject matter of arbitration. So they claim the ordinance conflicts with their collective bargaining agreement, and their collective bargaining agreement trumps, so there's no arbitration. adding this language clarifies that in the cases where the complaint against an officer is sustained by an independent arbitrator, the chief of police shall accept the arbitrator's findings and may impose any disciplinary action he or she deems appropriate without being bound by mandatory punishment specified under Hartford Police Department's Code of Conduct for any sustained violation. Meaning the chief of police may or may not issue any punishment. And putting in the part about the Code of Conduct is important because, without belaboring it, the union's going to argue that if the chief has to go back and issue punishment on a finding that a independent arbitrator found and the chief didn't, that kind of conflicts with the Code of Conduct, the hierarchy, the calculation, the way they look at discipline. So to get through all of that fog and to clarify once and for all to the union and people challenging this, arbitration isn't discipline. If you add that language, I think that gets us there. I would also suggest, and this is where I hope I'm not stepping out my lane, but in the language that's already in there, what I highlighted in blue, I would recommend you take that out. That says, in cases in which a complaint against an officer has been sustained, either by the chief of police or by the independent arbiter, the chief of police shall initiate the disciplinary process within 15 days. The union took a look at the word discipline and an arbitrator in the same sentence and said, basically, see, this is discipline. If you take out, cross out that language or the independent arbitrator, you lose nothing except the argument from the union that this is discipline. Take that language out and put the language underneath, and I believe that resolves this challenge by the union that arbitration conflicts with their CBA. With respect to page 9, I think it's important that the Inspector General have the ability to directly reach out to the mayor or anyone else, specifically the mayor, the executive, if he or she is experiencing problems with the Hartford Police Department. I'm not saying that I can't reach out now, but what I am saying is I don't know what the chain of command is. And I want to make sure that going forward, the Inspector General has the authority to reach out directly to the Hartford mayor and is not told down the road by maybe a different administration that that is not permitted. It just makes sense to me that if the board directs the Inspector General to send a letter and outline problems to the mayor, saying, Mayor, we're having problems with the police department, that should be permitted. And this will get rid of any possible challenge down the road that the Inspector General cannot contact the mayor directly as an employee of the city. Okay. Page 9. This has to do again with autonomy and independence. So the request here is to change the language. Obviously, City Council controls the purse strings, and obviously City Council I guess ratifies or agrees or creates the budget, and then the mayor takes that budget and does whatever he feels is appropriate, and that is my very limited understanding of how the budget works. I know that there is money earmarked for the CPRB every year. I'm not sure how this works, but I believe that money, the way the system is set up now, can be allocated for other things. Other distinct things other than the CPRB, and that the process that's permitted. My request is that there be an annual budget that is specifically allocated to the Inspector General's office for the use of the CPRB to get rid of, down the road, whatever mayor is around or whoever is making budget decisions, that they can't take money that was earmarked for the CPRB to use for other things. Obviously, the language adds that any money, it must be approved by the board. There has to be accountability. And that the board has to approve that budget, and that The Inspector General, with respect to that budget, must obviously follow all documenting, tracking, rules, regulations, whatever those safeguards are that any other employee of the city of Hartford or the state of Connecticut has with respect to spending money, that obviously must apply to the Inspector General. There has to be accountability if we're spending money. The language about on the bottom, hired by the Civilian Police Review Board, that staff really should be hired by the Civilian Police Review Board. Now, clearly it can be several members, other people, the executive, whatever, attend a interview, but really the Civilian Police Review Board should be either hiring or at least really having a substantial voice. The other thing I would suggest is adding the language of for good cause with respect to trying to remove any future Inspector General. The Inspector General's position should not be an at-will. Currently, I don't think it is, but it's not clear to me. But it shouldn't be that some mayor coming down the road doesn't agree with, let's say, an Inspector General issuing subpoenas and just terminates him because he's an at-will. There has to be some safeguards here to protect the independence of the Inspector General, and adding for good cause shown just adds a layer of due process. There has to be a good reason. It can't just be for an improper reason or for political reasons. So I guess here's the heart and the meat of the changes that I think would really help with respect to discovery. And again, discovery is, I use that as a legal term in court, but it really means the documents that Internal Affairs has, the police reports, body-worn camera videos, recordings, all the evidence, the stuff that they have that they review. I'm going to call it discovery. I think this better addresses the intent of City Council. City Council, I'm sure, did not intend the Inspector General to only have access to public records, what any citizen off the street could come and ask for and receive. I'm going to guess that City Council, and I know this, intended for the Inspector General to have the same materials as Internal Affairs, unless there's a statute prohibiting disclosure. So this language, and I can read it and bear with me, the Hartford Police Department's Internal Affairs Division shall promptly provide the Inspector General with access to and copies of all materials in its file, as well as any documents reviewed in connection with a citizen complaint without redaction. Currently, I get documents that are redacted. I get some documents where the names are redacted and I can't complete an investigation. And they won't give me the name because they claim it's confidential and not releasable through FOI. FOI is not the yardstick here, the measure of what should be turned over. The next language, though, goes to protect, to follow state law with respect to confidentiality. It says this requirement applies unless a record or document is specifically prohibited from disclosure by federal law or Connecticut statute governing confidentiality of records. There's a list of statutes that apply to confidentiality, a medical record, a psychiatric record, a DCF record. Those are well known in the court system. Any lawyer that practices in court and deals with discovery understands that. If there are DCF records or psychiatric records or something like that, yes, Internal Affairs can say there's a statute that prohibits that disclosure. I get that, and that's appropriate. But the next language says, excluding Connecticut General Statute Section 1-210 et sec. What does that mean? Excluding, but this does not mean the Freedom of Information Act. Let's make clear once and for all, this interpretation that FOI governs disclosure that's been deeply entrenched for 6 years here in the city of Hartford, that is not what we meant. If Internal Affairs says, hey, Inspector General, there are 3 records here that we cannot disclose because they are protected by state statute, they are required to just not turn over those records, but notify the Inspector General of the substance. What is it you're claiming? Oh, it's a DCF record. Okay, because that way the Inspector General can go to court if he or she feels that it's necessary. but the statute is complied with. It wasn't turned over, and yet the Inspector General knows what are they claiming. If the police department is going to hold on to those documents because it claims, well, one of these is a document we can't turn over, then they can't go forward with their findings until we get our documents. It stops the clock, and it's a fairness provision. You can't claim we can't have a document to block us from investigating and then say, by ordinance, you're not complying with your timelines. So they can't go forward, but there is a guardrail here, subject to the provisions earlier, which are that for good cause the mayor can go ahead or do it, or if the Inspector General has substantial evidence. So this just refers back to some safeguards. Let me just show you what I currently have. This is the problem, okay? These are our current, I think a picture paints is better than 1,000 words, right? Whatever the saying is. Here is our pending open cases. These cases, some of them go back to over 1 year. 2 of them are on hold for 1 year because the union blocked my ability to interview officers, and that's pending. 1 year, these city residents cannot have their right to the CPRB review because the union has blocked my ability to interview officers. Look at the rest of these. Look at cases going back to 2025. 243 days have passed, and we still don't have discovery on some of these cases. I mean, this is just ridiculous. This is not workable. This is not complying with the ordinance. Okay. With respect to subpoenas, on page 10, the union has also, the Hartford Police Department, I'm in litigation right now, issued subpoenas, and the union and the Hartford Police Department have basically brought suit to try to quash or have a court say that, rule that no, I'm not entitled to these materials. One of the arguments they make is that the state statute that vested authority in municipalities in Hartford for CPRBs to have subpoenas says it's the board that has subpoenas, and that our ordinance sounds like it's the Inspector General that has subpoenas. I think that's a lot of fog, but if you just change the language and clarify it, that addresses that challenge. The subpoena powers, the Inspector General can serve subpoenas subject to the authority and issuance from the CPRB, which, by the way, is how we did our subpoenas. The CPRB voted. I didn't issue subpoenas willy-nilly. I put it before the board. They voted. They authorized the subpoenas. But just to clarify that legal challenge, make it clear that the board has the subpoena power. Make it also clear with respect to subpoenas that the subpoenas for items or for testimony, and that the Inspector General or a licensed attorney can go to court and seek remedies if the police department is not complying with these subpoenas. So make that clear in this language. And finally, on page 10, again, with respect to evidence, going right back to the same thing, add language. Here, this talks about the Inspector General shall complete their investigation and provide their findings to the CPRB. This says 45 days of receiving a copy of the citizen's complaint. And then again, it's a subject to the provisions above, which really toll the clock until the police turn over the documents. We cannot follow the law that sets timelines for investigations when the Hartford Police Department will not comply with turning those over and are blocking us. I have 2 slides. I put these together. Actually, the chair put these together. They're beautiful visuals. I won't go through them, but they are available. In a nutshell, these are the topics that we talked about. Basically, for example, on the top one, problem 1, discovery. A summary of what is addressed here to the right of that in the amendments to address that, and the rationale to the right is why. So it's the problem, what is the language we recommend, and why. So said much easier and quicker and concise that I talked about, but these are the two slides that are available to you. So let me just stop sharing for a minute. Thank you, because I know I talked for a long time, almost an hour, but this is really important to me. And again, this is not mere hyperbole. We're at a crossroads. This either is or is not important to the people of the city of Hartford. And if it is important, the ordinance has to be changed. And if for some reason the decision is made that it doesn't have the importance, or there's not the appetite that there was in 2020 after George Floyd, or for whatever reason, if the changes are not made, let's just own it and acknowledge that the CPRB is not going to be the vision that the courageous council of 2020 had. So I'm here if you have questions, but I really appreciate the time and the forum, the availability to sit here and present my case. It's been very nice. I appreciate it.
Thank you. Hold on a second.
Thank you, Inspector General. Let me just log out from this thing. Okay, great. We don't have an echo. Still have an echo. Councilman Misham, you have questions? You have the floor.
Thank you, Madam Chair. Excuse me, Inspector General Lopez. Just a question to clarify the distinction between the records that are available for FOIA and what would be available to you. I understand that the union's taking this narrower view and redacting on the theory that there's a lot of stuff in these records that the public, police officers are individuals, they have employment stuff, they have stuff that maybe shouldn't be public and wouldn't go to the public. Is my understanding right that if you get records, you as the Inspector General, unredacted, those aren't public, right? You're not sharing those out to the world.
So my understanding and my interpretation and our policy here is that any documents that we get go into our case file, and they are labeled as confidential and not releasable. So that if anybody ever made a FOI request, they're flagged with a header or whatever, that these are not to be released under FOI, and that if somebody makes an FOI request, they're materials that I'm entitled to because I'm an official investigator for the city of Hartford. They're not materials that are releasable to the public. So that is correct. And if I can add, can I give you an example of some of the problems? So for example, if there's a case pending in criminal court, certainly under freedom of information, the prosecutor can be alerted, and the police department may, it's discretionary, say, well, we're not going to turn over these documents because there's a case pending in court. We're going to exercise that discretion under FOI to not turn it over. So that is an FOI exemption that applies to the public. So I'm being told that if somebody complained who got arrested for anything, some minor misdemeanor, and they complained about how the police department treated them, the Hartford Internal Affairs has told me, well, the state's attorney don't want these released, so you're not getting them. And my response is, under what authority does the state's prosecutor, the state's attorney, have to stop me from getting records? And their answer is FOI. So pending criminal cases in court, and you know as well as I do, that court cases can take a lot of time. And so, another problem is any case that involves an alleged domestic violence victim, they will not even give me the name. So what we have here is a situation where let's say a woman makes a complaint that she called 911, she's a domestic violence victim, and the police officers, when they came, she summoned for help. They allegedly mistreated her or interacted with her in a disrespectful manner, whatever her complaint is. She doesn't have the right, the way the system is set up right now through Internal Affairs, for the CPRB to investigate her case because the police department won't give me her name. So that group of people, domestic violence, alleged domestic violence victims, are being denied their right under city law for CPRB review. If that doesn't scream problems, I don't know what does.
Thank you.
Thank you.
Councilman Thomas, do you have any questions?
No, Madam President, I do not. Thank you so much for the presentation,
Thank you.
Inspector Lopez.
Thank you.
And thank you for the example just now that you gave as well. That was very eye-opening, truly.
There are more examples. I just think that's shocking.
It is. It is.
Inspector General Lopez, thank you for that thorough presentation. And piggyback on Councilman Thomas's, the graphics kind of helped us out. I'm going to ask that presentation that you have, if you could send it out to my office so that we can share it with all city council, so they are aware of all of the changes, and also see the PowerPoint presentation with the examples. And like I said, July 20th is when we're going to have the public hearing, and we're going to hear what the residents of the city of Hartford have to say with regards to the CPRB ordinance. Chairperson Harmon, do you have any comments that you would like to share with the city council?
No, yeah, thank you so much for having us though. And again, we really appreciate the opportunity for the public to weigh in on Monday as well. Obviously, we'll try to get folks there to speak on our behalf. We certainly appreciate the time to speak as well. So thank you for this opportunity, and thank you also for the opportunity next Monday.
Wonderful. So I will entertain a motion to keep the CPRB in committee pending our public hearing Monday, July 20th at 7 p.m. Do I have a motion from my council colleagues?
I make that motion.
And do I have a second?
Second.
A motion has been made and properly second to keep this ordinance in committee until we hear from the great residents of the city of Hartford. Again, public hearing Monday, July 20th at 7 p.m. All those in favor signify by saying aye.
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 Any nays, any abstentions? The ayes have it. This will reside until further notice in the Quality of Life and Public Safety Committee meeting. Next items on the agendas are item 2.3, Chief Ravella with the Hartford Police Department. Anyone from the public that would like a copy of the presentation from the police department, from the fire department, or from ESNT, you can reach out to my office or via email, phone call, and we would gladly get you those presentations. Now, without further ado, I would like to ask for a motion for adjournment since we have no other business to conduct this evening.
I make that motion.
Do I have a second?
Second.
Motion has been made and properly second. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Any nays, any abstentions? The ayes have it. This meeting is adjourned. Thank you, everyone, for your time, and have a great night. Thank you.
Good night.
Good night.